Okay, so you remember that the majority leader had filed an application asking that the Speaker should not determine any matter that would lead to vacancies being created in Parliament. Despite the pendency of that particular application, the minority leader, Honourable Atuforson, raised the matter on the floor of Parliament, sidestepping an earlier intention served by the Honourable Haruna Idrisu. And the Speaker, despite having been told that there was an application pending in court to that effect, granted audience to the House to hear the matter. Subsequently, he made a ruling 2 days later, which ruling in effect vacated those seats. The majority leader, feeling aggrieved, went back to court to say that, well, I was before you.
The same Supreme Court.
Exactly, the same Supreme Court. I was before you asking that you should stay the hands of the Speaker. The matter was not heard. The applications I had filed to that effect had not been determined yet. The Speaker has made a decision that would injure my interests and the interests of my side in Parliament on the matter. So please intervene and stop the Speaker from going on with what he has done. That was granted on the 17th of on the 18th of October. Now the Speaker,
so that's a Friday.
Exactly. So the Speaker agreed.
But it was ex-party.
Yeah, it was ex-party.
So the majority leader went without notice to the other side.
Yeah, that's right.
Okay.
So the Speaker, aggrieved by the decision of the Supreme Court, filed an application inviting the court to take a second look at his own decision and to vacate it or to set it aside, because in his view, the court did not have the authority to have even considered the matter in the first place, and that even if there was an issue, that was not the forum to deal with it. The court heard the matter yesterday and said, look, the Speaker, we do not agree with you. File the relevant processes. Let's look into the matter proper and decide it.
I'm told there were two preliminary issues. The Attorney General complained about some specific wording of the Speaker's legal team, and the Speaker's legal team also asked for one of the justices on the panel to be removed. I'm told both did not succeed.
Yeah, to a large extent, if you look at it, the Speaker's characterization through his lawyers of what was to be done by the court suggested that they were basically doing a partisan job there. So the Attorney General took strong exception to it and said that that should be struck down, because the court is not there to do the bidding of the party or a group of parties. You understand? And then also, you do know that the respected justice from the Volta region at some point was associated with the MPP. And there is a suggestion that he even at some point attempted to become a member of Parliament at the ticket of the party, if those facts are correct. Of course, he himself had said publicly when he appeared before the vetting committee or the appointments committee that he, prior to joining the bench, had resigned from the MPP as a party. Now, those matters came up before the appointments committee. The appointments committee scrutinized them.
Of Parliament.
Yes,
still passed him.
And then passed him. The House passed him to become a justice of the Supreme Court. The President subsequently appointed him to that office. Now, the Speaker took exception to him sitting on the panel that decided the original matter and said that by reason of his previous association with the party, it would seem that his interest still aligns with the party in government, and therefore he was less likely to be fair and impartial in dealing with the matter. And therefore he should recuse himself. Of course, these are matters that normally come up, whether a judge is likely to be seen to be biased towards one party or the other. Normally when these things come up, sometimes the judges themselves would advise themselves, or that a court higher than them would make a decision to that effect. On this occasion, the court looked at the matter and said, look, first of all, these matters came before the appointments committee. They were considered, and the decision was made to pass him. Therefore, this is not the forum to come and relitigate that matter. Parliament, in its own wisdom, which has the authority to approve such nominations, had approved them already. So you cannot come here and expect us to overturn the will of Parliament. The issue it raises, though, is whether that would throw doubts in the minds of people as to whether there was really justice being done in the case, because justice must not only be done but must be seen to have been done. So that is an entirely different matter. Except to say that there's a rule in the common law world, which is the principle of necessity, which basically says that, well, you may have grievances with the person who is sitting on your matter, but if that person is the person who must make the decision, you should allow the person to make the decision, unless there's evidence to show that some considerations completely unconnected to the matter in issue weighed in on his decision, which in effect is injurious to your interest.
So these two preliminary matters were dealt with. Now, for some reason, so then the issue that Mr. Bagbin took, that the court should overturn its own stay of execution, of course, the court disagreed with him.
Yes.
Right? So you can say that was Bagbin's substantive matter that was dealt with.
No, not substantive.
No, I'm saying in the context of what he took to court for hearing yesterday, the substantive matter has not been heard.
Yeah, that's true.
Because I'm saying that Bagbin's, because don't forget we've dealt with two preliminary issues.
Application.
Yes, we are trying to help each other. So I'm saying the main issue was what Bagbin wanted them to do, but before that he had asked for the recusing of the judge, which was not agreed. But the court disagreed with him also on asking the Supreme Court to reverse its own decision. They did disagree with him.
Yeah, they disagreed with him. So the fundamental basis for his application was that the court did not have the powers to give the orders that it made. And therefore, the court should re-examine his own orders and his own powers and set aside that order. The court said that no, these matters are properly within their authority to look into. The existence of jurisdiction is one thing. As to whether the jurisdiction has been properly invoked is another. To explain briefly, to have the power to look into something is one issue, and they have that.
And
matter.
Whether you've come before me in the right way,
exactly,
for me to look into it, another issue.
And the Chief Justice made that point clearly. So what the court is saying is that, look, you file your processes. We'll look into the substance of what the majority leader has brought, and to even examine whether our jurisdiction has been properly invoked in the first place, and then proceed to make a decision. That is my respectful understanding.
Okay, so a couple of issues arise from here. The main issue to be determined is still the issue the majority leader took to the Supreme Court before the Speaker's October 16 ruling. So that matter will be heard when?
On the 11th, it will be heard and most likely decided that day.
Good. Now, the CJ had asked the Speaker's lawyer to present his whatever they call
side of the case,
and was wondering why he hadn't done that. But while that was going on, the AG also said he didn't even think that the Speaker's side were needed in the matter, and that he raised two issues: that the matter that a majority leader has taken to the Supreme Court of Interpretation does not need a response from the Speaker's side, because the matter can be dealt with on its own. And number two, he didn't think that even counsel for the Speaker was legitimate, because the process to have been gone through to appoint him, he believes, had not been done. What was the court's view on those two matters?
Okay, so here's the thing. This is an often litigated matter. Article 88 of the Constitution is clear that it is the Attorney General who shall represent the interests of the state on matters like this. If a constitutional matter comes up and the state is sued, it's the AG who shall file the necessary processes. But in a number of decisions of the court, they have taken the view that there may be times where the interests of the Attorney General will not align with a particular institution of state that is sued. For example, in the current case, the Speaker of Parliament made a decision. That decision is being litigated by a member of the House. Because the member of the House in question happens to be sort of a member of cabinet. The Attorney General is a member of cabinet. And there is a likelihood that they might agree on...
There's no way the Attorney General will defend the Speaker in this matter.
That's
exactly what you're trying to say.
So in that sense, you need to hear from the horse's own mouth. Why did you do A, B, and C? So they have developed this practice or convention, if you like, or this rule, that in those cases, the people directly affected or whose actions are being challenged should come and so that you understand? So that is what has developed. Now, it's something that has, of course, in my own case, the Parliament has been sued. So Parliament is filing its own processes in that respect. But the Attorney General sought to elevate that matter yesterday because, in his view, he thought that Parliament was trying to, if you like, delay the processes. Do you understand? So the court should just simply remove Parliament.
So that it's just going to determine the matter. But the court did not agree. No. So they will give the counsel for the Speaker how many days to bring his...
as I understand, it's supposed to happen within 7 days. So within 7 days, they must file the right processes. And then on the 11th...
So today is 31st.
Yes.
So by 7th or 8th, they would have submitted or filed, as you people use the word.
Yes.
So on 11th October, what are they deciding?
So on the 11th
November.
11th November, what are they doing?
So this is where the substantive matter that Alex Afenyo-Markin took to court will be heard. And by that I mean his lawyers will state why they are in court and why they believe that there is an issue to be litigated before the Supreme Court and whether the Supreme Court is the right forum in the first place. They will make all of those arguments and put their own interpretation to what is an issue, Article 97 of the Constitution. And they will be asked questions. There will be a response from Parliament to that effect. Whether they agree or disagree, they will state so. And then the Attorney General would also be heard on the subject matter. As I understand it, the court would then, adjourn, not adjourn, basically suspend sitting, and go and consider the issues and come back.
Let me hear the legal arguments preferred, and I'll bring you the CJ's ruling in the next few moments. This is City Breakfast Show, taking you quickly through yesterday's legal gymnastics from the Supreme Court. Here are the two lawyers.
The first defendant's ruling is not a judicial decision, which is properly the type of order or ruling, which is the subject of the court's orders for stay of execution. At the very best, it's an administrative decision. It's not a judicial, it was not based on any judicial determination of any matter. Linked to that fact is the tribe's position that when we say stay of execution, we don't say it as a semantic expression, by way of semantics. It is based on the rules of the court. It's a statutory position that certain matters are liable to be progressed by way of what the law says, execution. And the law defines how to execute things, not from anywhere, but from the judgments of courts. The Speaker's ruling is not one of them.
The Speaker's ruling is not executable.
It's not executable within the meaning of the rules that govern the practice before this court and any other court for that matter. That's the third ground. And the fourth ground, let me make reference to the cases. Is that the processes, the processes initiated for purposes of the order, the ex parte application, was made in breach of the rules of natural justice. And this arises from a plain reading of the rules of the High Court, which provide for applications, because the rules in this court don't provide extensively for applications. My lords, I will refer to Order 19 of the rules of the High Court. Which say clear that every application must be made on notice. That's the first rule, which allows for ex parte applications. Our submission is that the rule 3 of 19 talks about ex parte applications, and it says subject to Rule 1, sub Rule 3. That's of Order 19 rule. May be made ex parte where any of the rules provides. To circumstances the court considers it proper to permit the application to be made. Now that's how we should read the sub-rules in context. The court may make an order ex parte on such terms and subject to such undertakings as it considers just, where it is satisfied that the delay caused by proceeding in the ordinary way would or might entail irreparable damage or serious mischief. Now, my Lord, we are dealing with a plaintiff who has demonstrated that he is capable of getting the court to sit at very short hours. He files his ex parte application at 12:40. He gets the panel of the court to sit at 2. Our submission is that he should have made it on notice, together with a motion for abridgment of time. There was an intervening Monday before Parliament would next sit, and the first defendant would at least have been given an opportunity on that presentation record on the grounds and basis for that application. And so that's the reason why we contend that the application itself did not properly come within the exception to the rule that he should have come on notice, because it was always possible, given the facts of this case.
We submit that the instant application is offensive to the rules of procedure of this honorable court, is unknown to the laws governing the jurisdiction of the court. The first point we make respectfully is that the Constitution has set out in clear terms the manner in which the decision of the court can be made. This application completely violates the laid down procedure for challenging a decision of the court in the Constitution. Article 133 clause 1. 133 clause 1 of the Constitution vests the Supreme Court with power to, and I quote, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Respectfully, the instant application seeks an order setting aside the process and proceedings of the court and vacating the order of the court. Respectfully, the decision in question, the exercise of right. Respectfully, Article 133 clause 1, the review, 133, I'm sorry, 133, the review is on the court. Respectfully, my contention is that this provision is a rule under which a person aggrieved by a decision of the court comes by to seek a review or variation of the decision. The instant application is not an application for review. It doesn't invoke the court's review powers, and is therefore unknown to the laws governing the jurisdiction of the court. Especially Article 134 also vests the Supreme Court with the same powers of review of a decision of a single justice. Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed, varied, or discharged, the procedure for doing so is as set out in the Constitution. And this is not. The meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, counsel for the first defendant, on which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a civil case in it. And totally, his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect of a provision of the Constitution than the instant case. But indeed, my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoked the decision of the Supreme Court has to be set aside. And that would be the basis for lawless conduct. And this honorable court owes a duty not to encourage him. But I'm fortified in this proposition by the locus classicus on the matter to forward an Attorney General reported in 1980 Ghana Law Report at page 637.
So those were the two. First, we had lawyer Thaddeus Sorry, counsel for the Speaker, and then the Attorney General, who was also on his feet. Now let's hear the CJ, the Chief Justice's ruling on the matter.
By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker, the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision, and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker. The controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. Clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins High Courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte, and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes For the above reasons, the application is refused.
So that was the Chief Justice Gertrude Torkornoo. So the big day is 11th, since such 11th of November 2024 for that matter to be heard. There's a lot of interesting cases. And you know, the other interesting thing is that we are seeing Parliament and the Supreme Court interpose quite a bit, because even in the LGBTQ case as well, which we understand there will be a development today, it's also a Parliament issue. When there's a Supreme Court has been invited to take an action there. I think we've discussed this in the past, where the three arms of government are having to interact in a way where in the past it was at a respectful deference to each other, but the circumstances of our competitive policies have forced a lot of the parliamentary matters to be sent to the bosom of the Supreme Court. And I think the CJ was quite clear when she said, even if it comes to the executive, they have the power as the judiciary to declare even the president or the vice president's actions unconstitutional. Yeah. Now, I don't know if anybody has, I don't know how, to what extent we've tested that. I think there have been a few cases where that has been tested.
Oh, yes. I mean, I mentioned on television the other day the celebration of coup anniversaries under the Rawlings administration, which the Supreme Court said you can't use public funds for that purpose. Of course, when the president did his state of emergency, which was done during the COVID period, of course, the court belatedly, rather unfortunately, with great respect, decided the matter after the matter was really of no moment, but it has set a particular precedent. So I can mention a number of cases in which the courts held that the executive acted in excess of constitutional requirement. The issue, though, is whether the timing, so for instance, Domelevo's case, it was obvious that the presidency overstepped its bounds by forcing Domelevo to go on early retirement, in essence, or to go proceed.
Has the Supreme Court had the chance to speak about that delay, or I mean, call it delay, the timelines, because somebody has been unlawfully removed, and he's been asked to go home, and then I will almost say posthumously, come out to say, well, he was wrongly removed.
Truly unfortunate.
Have they had the chance at any forum to address that?
Not that I know of. What I know they generally say is that they are under so much stress and burden with cases that have come before them, because the Supreme Court of Ghana is unique in its own right. Every little thing can be applied, can be appealed all the way to the Supreme Court.
You said something that justice must not only be done, but it must be manifestly seen to be done. So if a Supreme Court, a man has been removed, I'm going to the level now, a man has been removed, and the case has come before you, and you waited for him to be replaced, and he's basically home, and his age has even passed the age, and then you come out to say he was unlawfully removed. Aren't you weakening yourself and rendering your own judgments unenforceable? Because it's only a matter of what is there on paper, but the action has already damaged the person's life.
You see, that is to say that what happened in that case, I mean, admittedly, is completely unacceptable, with great respect to the Supreme Court, because there was either real breach or threatened breach of the Constitution. And one would have respectfully, with great respect to the Supreme Court, expected that the court will act timeously, deal with the matter while the iron was still very hot, and to tell the president in your face that, look, you may have the power to appoint, but you do not have the power to ask the guy to leave office just the way you were doing. And that if you wanted to take him out of office, use the proper structures provided for by the Constitution. You can't just write an administrative letter and say the man should proceed on leave, and then subsequently say that his age differed from A, B, C, D, and use that as a process to get him out. So I think all of us must admit that was a great oversight on the part of the Supreme Court, with all due respect.
Listening to the CJ deliver a ruling, did you sense pressure? Because I felt like she was, I think there was a couple of occasions where she said, people say this, people say that, but that's not what it is. It seems as if the commentary and the public backlash may be getting to them, because she, I don't know, you are a lawyer, so you will know this. I felt like somehow the commentary is affecting them, and they are having to explain more why they are doing what they are doing.
Yeah, that's right, Bernard. You see, it is actually truly unfortunate. You know, there's a friend of ours, a common friend of ours, who told me something, that you see, law in its purest sense, without any contamination, is a sweet thing, right? But the moment you mix that with even the tiniest bit of politics, you have created the most potent witchcraft ever conjured by man. I'm crediting Kojo, not in his exact words. But you see, what it is that some things are just so simple that you would expect that the average human with average intelligence would follow what has been written down and that things will go normally. But sometimes people put a spin on what, is before the court and what is being decided. Of course, there are times that utterances from judges themselves do not help the matters. But we have agreed as a democracy that this is the path that we have chosen. That when there is a dispute, that dispute must be settled by a particular body. You may disagree as to how people came to be members of the panel or how they came to be members of the bench. But there are processes that ought to have been engaged. If those processes allow those people to go and sit there, then when they make a decision, while we can criticize them constructively as to ensure that going forward things improve, we should not be insulting them personally, attacking their family, doing funny photographs of them, and all kinds of things that we write on social media. Because whether we like it or not, we have created a special category, and I'm using the word advisedly, of people who should be wise enough to look at our rules, the rule books, and say that this is what the rules say.
But now, is it also fair for politicians on both sides to because you see the justices they are supposed to be law, right? But there's a lot of things that end up in court because of politics. So, look, there's a fight in Parliament for political advantage. It's found its way into the court. So you cannot derobe politics away from that law. So even though it's a legal question they are going to interpret, at the basis of all the dispute is politics. So I'm not even talking about the social media commentary. There are some cases which are by nature political. So even though they end up in court as legal issues, the basis of all that argument they are arguing is politics.
But you see, this particular case, with the greatest respect, it's not a political case. It's a constitutional matter.
No. I'm not talking about the case before the Supreme Court. I'm talking about the circumstances that led to them going to court.
Yeah, you see,
because what was happening with I sit on the left, I'll do this. It's politics, not law.
So let's ask ourselves.
So if 4 MPs go and file that they will run independent or run another party, that's politics. Then it becomes a question of law if the dispute cannot be resolved in Parliament and therefore it goes to court.
Yeah, because
so I'm saying that the matter is a political matter.
So you see, so ideally,
it's a political matter.
In any country where people are behaving properly, officials are behaving properly, the matter comes up. If you don't have the power to deal with it, say that, look, this matter, I don't have the power to deal with it. If you believe that you have the power to deal with it, you deal with it. And somebody says that, you don't have the power to deal with it. So the people who have been given the power to deal with this matter, they should come inside and look inside and determine what we should do. Once those people have been called in, the first thing you should do is, on this matter, well, I disagree with you. I would allow you to do what you have to do. In the meantime, I'm respecting your decision. Look, let's continue proceedings until after the court itself says that, look, I did the right thing or I did not do the right thing. In a properly functioning democracy, that is what responsible people do. But you see, you have created a situation where...
Sky, let's be careful. Even in the US, political competition drives a lot of institutions to the brink. When people are desperate for power, when people would leave no stone unturned to get an advantage, they will do their politics to its extreme, which then puts pressure on Parliament and put pressure on the courts. And again, that's the nature of democracy. But we need to ask ourselves, are we building or destroying our institutions? That's one. Number two, the point about sometimes the institutions themselves must work to protect their own reputation. Okay, so the point you made about the Malevo case is regrettable. And sometimes the courts must help themselves in consistency of the way they apply the law. Because a lot of the people in the public, we don't understand law. And sometimes when you people start doing your law, we just get lost. But you may win the legal battle but lose the public confidence. So I'm coming. So we need to also understand that whatever we are doing it on behalf of the public. So we must carry them along. We must I even think there must be open days sometimes where they say, look, today is the day, go and ask a lawyer a question, come to the court, there's no court, we are on legal vacation. Let's explain how we do things to you. The communication department must come, they must do press conferences and explain some issues, because the public is interpreting what you are doing through a certain filter, right? So you may be robed with the power to make that decision, but if the public don't have confidence in the institution, we all suffer. And sometimes the institution must look in the mirror and say, well, how are we looking in the eyes of the public?
Bernard, you see, you have made a valid point, but it is only valid in my respectful view to a limited extent. Why? Look, there are politicians who are lawyers, and in every country where democracy is functioning properly and lawyers know what the law is, they will say that, oh, even though I may disagree with the court, I don't go to the court of public opinion and put a negative spin on what the court has done. The problem we have is not that we should not criticize the court. It is because some people, well aware of what the law is, knowing full well that the Supreme Court has the power to do a particular thing, and you can criticize that in a measured way, they go to the court of public opinion and then poison the atmosphere, so that people who are not as educated as others get to believe that, oh, the politician on my side is saying that this is what this means, and therefore that is what it means. When they know, when you meet them in private, they tell you that, oh, yes, we agree that this is what, but look, we are doing politics. We have to stop being dishonest. The question is whether the Supreme Court, as established by law under our constitution, is similar to what is in the US. No, they are not the same institutions. Because in our case, the Constitution says so expressly that when there is a dispute as to what a provision of the Constitution means, the persons to resolve it, they sit on the Supreme Court. It is no other person. They have exclusive jurisdiction to interpret and enforce. Just a minute.
We are not arguing with the right of the court to do that.
Hold on.
They are arguing as to whether it is being fairly and consistently done.
Hold on. Let me finish. I will come to that. Let me come to that. And then in the US, they arrogated the Supreme. It's not written in the US Constitution that they have the power to interpret the Constitution. That's why some presidents said in the past that, look, we have our own power to interpret. But in our case, we wrote it in express words. The Supreme Court in the US arrogated themselves the authority to do that. And over time, it's been accepted that that is the way to go. So let's get the distinction clearly. And then also, as I've already said repeatedly, when a court makes a decision and you disagree with it, you can robustly criticize the decision.
Yeah.
You can write academic papers to criticize the decision. What we have in Ghana is the people don't talk law. They then descend into the arena of politics and then insult and attack the judiciary. Now, if Justice Jaiwu, yes, of course, at some point we're told he was a member of the MPP. But he's not the only politician to ever make it to the Supreme Court. In fact, throughout our history, we have had politicians make it onto the bench. You understand? But the central question you should ask is, at the relevant time that the judge is making the decision, was he influenced by some other consideration as opposed to the law he was made to decide upon? If that consideration can be ascertained, then you use that as basis to say that you do the wrong thing some of the time.
Don't get worked. See, I'm making fundamental points to the questions I'm asking. Now, we are in the media. People criticize us sometimes fairly, sometimes unfairly.
Yes.
The question I tell my journalists is that make sure you are doing the right thing. If you do the wrong thing and people criticize you, you will take it. If you do the right thing and people criticize you, you still take it. But make sure you are doing the right thing. So your stock in the public eyes has two things. The filter through which people look at you and your own actions. So I am saying that what is in your control as a journalist is to make sure you are accurate, you are objective. Some people will never like you. Some people always criticize you. Some people play politics what you do. Some people brand you. But over time, the truth will stand. Fair enough. Now we are saying that it is in our interest to protect institutions, but institutions must also act in a way that gives public confidence. It's a balancing act.
I think.
Hold on. So what I've said is not something to contradict.
No. I'm saying that I made that concession.
No, I'm trying to.
For instance, in the Dominic level case, I use that specific example to make the point.
I'm just concluding what we are saying. I'm saying that there are two sides of the responsibility.
Yes.
The people who are acting must act in a way that inures public confidence in the way they do their things, whether it's journalists or judges or whatever, or parliament.
Yes.
we also have to protect institutions
and
not overly politicize what they do.
That is the real problem.
No, they are both problems.
Yeah, that's
because if I, as a journalist, every morning come on air and I'm being unethical in what I do, you can't say because media freedom is guaranteed, I can continue doing that.
No,
I am undermining my own freedom by my actions. So what I'm saying is that it's a balancing act, right? You may say that the weight of the responsibility rests on lawyers who should know better in terms of protecting the judiciary. No problem. But the judiciary also sometimes needs to know how its own actions affect perceptions about it.
I made that point.
So I can also make it.
No, you see, I'm just saying.
No, why? The fact that you made that point does not mean because we are trying to arrive at a conclusion so we can all help society.
Okay, go on.
And we have both said that. You see, Sky, there are always two sides to an issue.
Bernard, you see, what I'm trying to say is that, look, you see, my beef really is that the courts are not always right. So when they get it wrong, the process has inbuilt mechanisms for ensuring that they do the right thing. So go and engage that process.
Fair enough.
That does not mean that you should not criticize them, right? But you have a whole member of parliament sit on Facebook and said that you have made some hopeless decision, come to the court, come to parliament and enforce it. I mean, a member of parliament who should have a passable level of intelligence, you should expect that would write some, even if you disagree, say so.
You shouldn't descend to the arena.
Exactly, that's the point I'm making.
That is true.
What we are doing is to destroy these institutions, and it doesn't help us.
There should be decorum and there should be a more respectful way.
Exactly,
of
that's all I'm saying.
Which is interesting because sometimes the more senior legal people, even in opposition, do not use the words that some of the younger ones use.
Yes.
You follow me? So you will see experienced lawyers on both sides who feel aggrieved by issues will be more measured, possibly because they are more experienced. All right, and so they know from history that if you've done law for 40 years, you know that can go your way or not go your way. But again, the way the public works now, social media is easy. It's very easy to say things and people follow you. And there's also a lot of people who have this illusion of knowledge that because I listen to the radio and I hear lawyers talk, I also understand the law or any other subject. All right, it's a reality you have to deal with. But when you are working as a judiciary in that context, I'll give you an example. Yesterday, I was watching an advert on TV. The EC did an advert where they said the balloting that we did for the voting was clear. It was an EC advert on TV. It was on ChannelOne TV. They said the balloting, some people were talking about, the EC is manipulating the balloting. And the guy came and said, no. We ballot for the right to, we ballot through levels. We ballot first to choose which order we will vote, as in who will pick first, and then we ballot on which order will. So the EC has realized that there is a certain view about its work. So now, they are not just doing public education on how to vote, they're also trying to set the record straight. Now, I think that the judiciary has to do some of that because, don't forget, from even Anna's time, okay, and for me, we don't get anything when we destroy institutions. We all suffer for it, all right? But it is a collective responsibility, and I think if for example, let me give you an example. Afrobarometer, the lack of trust institutions. And this is in Afrobarometer from 2012 to 2024. You see, so sometimes we make it seem as if it's only recently that people are criticizing the judiciary. The reduction in trust for institutions, presidency, parliament, judiciary, historically has been coming down for the past.
Why?
No, hold on. I'm not yet there. Hold on. I'm just making the point. Wait. Don't.
Because at the time,
don't run.
it was
Let's
the
relax.
MPP people who were being irresponsible and attacking the judiciary all the time.
Take your time. I'm saying, take your time. You see, what you are not listening to me. Afrobarometer has shown you that all institutions, trust in them is coming down. Right? From Office of the President, Parliament, Judiciary, ministries, departments, local government officials. So let's not be quick to just point to one cause. If there's a general decline in trust in institutions across the board over a decade and a half, there may be more nuanced causes than just some irresponsible politician attacking everybody.
That is.
Do you understand what I'm saying? So the research has shown us the what. We can then go and diagnose the why. I think the institutions involved, when the police are accused of being corrupt and IGP comes out to write a long letter to say it's not fair, he's measuring that based on his effort. But I'm saying that just like us, we do our work, people criticize us. Take that feedback, look at it, and make sure you're on the straight and narrow, and hope that over time the public confidence will rise. I think that's the best approach to use. But if you blame other people for your own, if you say the reason people don't trust me is because one or two people are criticizing me, I'm saying that if you look at that Afrobarometer thing that we read, there are about 7 institutions all coming down. Okay, so the right thing to do is to do a self-diagnosis and say, why are we declining in public trust? And what can we do to bring it back? If it includes engaging the politicians and say, guys, the way you do your policy is not helping. In addition to the way we also do our work, we should do it that way. But I hesitate to agree to saying the reason why institutions are coming down is because we're attacking them. That's the end of the matter.
I think that is to mischaracterize what I've said.
Then characterize it.
By introducing the Domolovo example,
yes,
I had made a concession that the judiciary itself has contributed to this matter.
Okay.
So don't characterize it as me saying that it is only because they are criticizing. But the unfair criticism and the attacks are contributing to this matter in a very huge way, very substantial way. Why am I saying so? Until the Kufuor administration added a judge to the Supreme Court, or judges to the Supreme Court, as to increase the number for a decision made regarding Chachuchi Kata to be overturned, to a large extent, we did not have this problem. Although people held a view that Rawlings had packed the court with, apparatchiks, you understand? But the Supreme Court was not as attacked at the time as this. The court made a decision that the fast-track High Court was alien to the Constitution, and therefore let's not even go there. The president of the day felt aggrieved. Nana Addo Dankwa Akufo-Addo, as of the time the Attorney General, had to do something about it. John Kufuor made an appointment, or invited the Parliament to vet somebody and then to put justice. I've forgotten the name of the justice.
Afre.
Yeah, he must have been Afre. Yes, he must have been Afre. The late Afre. Added that to the panel, and what was the decision was reviewed. And on review, the court said that, as for the fast-track High Court, is the right thing. Now
so in that case, can you blame the public for feeling that the executive has influenced them?
No, hold on. You see, so first of all, the question we should ask is whether the president has the authority to do that. That's one thing. And whether the court has the power to review its own decision.
But does the public also have a right to believe what they want?
That's okay.
You see, we are not questioning your power. We are questioning whether the way you exercise the power is fair.
No,
you get it? So it's not. We are not. But
allow me to finish my point.
You are mischaracterizing what I'm saying.
I'm not mischaracterizing your point.
We don't disagree with the power for a judge to do what they do. But we also have a right to believe what we want about whether what you've done is right or wrong.
Okay, so you see, the proper attitude to such a development is to first of all explain that, look, the president has the power to appoint, right? And he has done that. The president has the power to call the Attorney General has the power to ask for review of a decision. That has been done. Now, on the law, the logic as articulated by the judges, is that in tandem with the law as we know it generally? That's the question you should ask. You don't go to the court of public opinion and say that, Kufuor is packing the...
No, I am not saying that. But you also have said before that when discretionary power is given to a person, the person must exercise the discretionary power. You use a certain word. I want to remember the word. You always
must be fair.
Yes, you always say that.
Candid.
You said that discretion
and not be capricious.
Exactly. You see, so while we don't quarrel with the discretionary power, if the people feel that discretionary power was capriciously used, they can still criticize the decision
and then take steps to have it cured. You understand?
No, you are a lawyer, so you believe in the system. Fine. I'm not having a quarrel with you. Okay. See, but what I'm saying is that don't forget, I'm using Afrobarometer. I'm telling you that over the past decade and a half, there has been a decline in trust in institutions. The sober thing to do is to go and ask why. Across the various areas, because it's police, it's judges, it's everybody. In fact, the only group that you can say survived the 3 cycles was the army. They came down and went back up. So as we speak, they have 65%. They are the most trusted. And some democratic purists are worried that, how can you have all these pillars of democracy and only the armed forces are trusted by the public? Can you legislate that? No. The public have a right to believe based on how they interpret everything. So I am saying that there are two responses. Institutions must all look at the report independently. Police, judiciary, everybody, and say, Charlie, how much of this is our cause and how much of this is spin?
I agree with you.
And distill that and address. That's all I'm saying. So even we in the media as well, we have a part of that to do. So I am not going to, I won't leave what I have to do as a journalist to correct my wrongs and focus on what other people are doing to harm me. Because there are people who do programs to attack me every day. I can't spend my life looking at that, but I can decide that, okay, let me make sure that I'm objective, I'm candid, I'm fair, I'm rigorous. Now, I believe that when I do that consistently, fair-minded people, because not everybody is fair-minded, fair-minded people will acquit me and say, this guy, we trust him.
Yeah, but you see...
And I'm saying that should be the attitude of all of us.
I agree with you. I agree with you largely. But you see, the point I'm also making is that, look, if a judge goes to collect koklo in order to direct justice in a certain way, we all will come out and say that this is wrong. And we should all be fair enough to come to that conclusion. And we did that in the, the Anas case. Except some people took the view that, the way the evidence was obtained had issues. But when a president exercises his authority to appoint, Parliament in its own wisdom says that, look, these people are good enough to go. They did not sit in the way of the matter to say that you don't become a Supreme Court judge. The person goes to sit and makes a decision. And you don't have any basis in law, really, to say that, this decision is wrong in law. All you say is that, because you happen to be a former NPP something or NDC something, that's why you took that decision. That is where my beef is, as a huge part of the problem. Because, look, Justice Atuguba, a distinguished justice by all standards, suffered that. Yeah. When they were hearing the petition, you and I sat here. I was hosting the hearing of the election petition. Anytime the man dissents,
somebody even went to insult him.
Exactly.
In fact, it even ended some people in jail.
Exactly. So you see, what I'm saying is that the MPP people, as of that time, knew that what they were doing was wrong, but they wanted to build a certain public perception and momentum.
It's become part of our political
against the Supreme Court.
Yes.
And the NDC is now following that particular path. Of course, recently Bernard Mona also followed that particular path. I'm saying that, look, these are the so-called special category of people. We ourselves say, when we have an issue, we should go to them to resolve it.
It is in our interest to protect.
It is in our interest to protect it.
Fair enough.
Once, if you have any basis in law,
you've made that point,
or in fact, to attack the decision, go back to them.
You've made that point, and you see that point is true. But that does not invalidate my addition.
No,
so you don't need to keep straining to repeat.
No, I'm just.
You can have two. You see, it's not opposing.
No, I agree to that.
You can have two side-by-side views. It's called balance. You see, so the fact that I emphasize one side and emphasize the other side doesn't mean I'm disagreeing with you. It's just basically saying that those two truths equally hold. That's the way life works.
Yeah, but I'm just saying that
your emphasis as a lawyer.
You see, I'm speaking as a lawyer.
I'm speaking
and
as
I
a
know what
person.
I am telling my colleagues. That you see, the level of irresponsibility. And let me add this. Let me add this,
bro.
I sat at home at some point and listened to a member of parliament, a celebrated member of parliament, say that judges have gone to make a decision and he disagrees, so they are interfering with the work of parliament, and I'm going to hold them to parliament so that there will be contempt.
That's his view.
I don't think
that's his view. He said contempt.
No, you see, hold on.
Someone say you go to parliament. Why is that a problem?
Hold on, Bernard. You see, it is not his view, because the constitution itself says that when a judge sitting in his chair makes a decision, not even the president,
no problem,
or the speaker can question that decision anywhere.
But
you see, a gullible public, with the greatest respect to the public, would swallow that hook, line, and sinker and say that, when judges make decisions parliament disagrees with, they can hold them before court for contempt.
You are the one who told us that in law, for everything there are two sides. So even though you strongly disagree with him, it's possible that some may agree with the greatest
respect.
There are very few things in this world that are Gandhi like that.
Bernard, hold on. With
the fact that somebody says he thinks that somebody is in contempt of parliament and you think that he's wrong,
Bernard,
does not necessarily mean that he's wrong.
Bernard, you see, with the greatest respect, yesterday I gave you a constitutional provision on the subject matter. It is not something that I am saying on the basis of this.
Is there such a thing as parliamentary contempt?
There is parliamentary contempt.
So maybe he's misapplying it, but that's his understanding. I'm saying that shouldn't be a problem you should litigate. That's his view.
It's a very, with great respect, miseducated
Yes,
view.
That's based on your view.
No, the language of the constitution is clear. Thank you very much.
Even Bible self people misinterpret it. What are you talking about? Well, that I don't even know where to go with it. But I will just say that all of us should go and read the Afrobarometer report. And the part that affects us, we should look at it with humility and do what it asks us to do. I looked at even private media. Yeah, about 19% of the people say they are mostly corrupt, and another 60-something say they are sometimes corrupt. Right? Public media too had the same. I need to think about that. I can't blame social media for that. I have to look at my own work and my consistency. Yes, there are people who go out to do minya, but that doesn't mean that I should say that means that all the negative perception is because of the social media. You have to. And the good thing is Afrobarometer have been since 1999. You see, and they've done it for everybody. So if you say police Afrobarometer is not fair, I think the Afrobarometer is fair. You get it? I think the most credible poll we had in the past 2 decades. Is there any poll
on this continent?
No. And they've done it in Ghana since 1999. Wow. Can you imagine? That's 24 years. So
it's as reasonable a measure of.
And they are releasing one tomorrow.
Public sentiment as you.
They are releasing the 10B tomorrow. So we should all go and collect it and read it quietly.
Josephine, you know what to do.
Charlie, Afrobarometer is coming.